All right, here in the Senate Judiciary, it's April 11th. We have Judge Counsel with us to discuss an amendment to page 41.
Good morning. For the record, Michelle Childs, Office of Legislative Counsel, and I'm just popping in on this one kind of narrow issue related to H41. This is the Ben's bill, but I got asked to kind of come in and help a little bit with the issue around fetal remains, and I think making sure that everybody feels confident that the language that is page 41 relating to abuse of a dead body or person is clearly not applicable to when we're talking about fetal remains. So you have an amendment in front of you. I think probably I'll just walk really quickly through this and then talk to you about some of the existing underlying laws, and then we'll circle back around to the language. So if you look at section 1, it's creating a new crime for abuse of a dead body. So it's in Title 13. You'll see subsection A is no person shall knowingly without legal authorization, and I'll talk about permits in a minute, intentionally, so there's your mens rea, burn, mutilate, disfigure, dismember, or destroy the dead body of a person. Subsection B says that essentially if someone violates subsection A, but does it explicitly for the purpose of concealing a crime or avoiding apprehension, prosecution, or conviction. So that's a separate subsection. And the reason for that is because there's a heightened penalty if the purpose for engaging in that conduct in subsection A was for the concealment of a crime. Subsection C is that no person shall commit sexual conduct upon the dead body of a person. Subsection D has the penalty. So as I mentioned, so if you look in D1, if someone violates subsection A, it's a 5-year felony. If they violate subsections B or C, it's a heightened 15-year penalty. And then you have the definitions there. Section 2, which is on page 2. This is an amendment to the provision in Title 18 that provides for a penalty, which is currently, you'll see, a 5-year felony for someone who essentially disposes of a dead body without a burial transit permit. So under current law, a person who buries and tombs or moves the dead body of a person has to obtain a burial transit permit. And then the statute lays out the certain people who can obtain that permit from. And if they don't obtain that permit, then they're subject to this existing penalty that you'll see in section 2. So the way that chapter 107 and Title 18 is organized, and I'm going to be talking about that chapter, but I just want to let you know that that's not something that we typically in judiciary deal with, or the judiciary lawyers. It's controlling around reporting of deaths and autopsies and things like that. So that's always done by the healthcare attorneys, and Katie works with them on those things. And there's a long, kind of complicated process for how all of the paperwork is done and regulates how what you have to do in terms of disposal of dead bodies. But it also has a subchapter on fetal deaths. There's a distinction in the chapter between a fetal death and the fetal remain and the body of a dead person. So there's two different terms that are used in existing law. And I'll just let you know, I'll read to you the definition of the fetal death. So fetal death means death prior to the complete expulsion or extraction from the mother of a product of conception. The death is indicated by the fact that after such separation, the fetus does not breathe or show any other evidence of life, such as beating of the heart, palpitation of the umbilical cord, or definite movement of voluntary muscles. So the way that 107 works is you have this one general subchapter, and that requires a permit for burying or transporting a dead body. And then you have another subchapter that pertains specifically to fetal deaths and reporting of fetal deaths. And there's certain requirements depending on the gestational age of the fetus and when it has to be reported and such. But there's a provision in the subchapter for fetal deaths that says that essentially you're required to get a permit for disposition of fetal remains. And if you violate that, you're subject to the same penalties that are currently in section 2. So the section 2 applies to essentially unauthorized disposition of a human body, and through cross-reference in the fetal deaths subchapter, it also applies to unauthorized disposition of fetal remains. So under current law, the way that I would interpret this would, and there's case law that supports this, is that so someone who miscarried, who disposed of fetal remains without their appropriate authorization and disposition permit could be subject to section 5211 currently. Okay, so there's through the cross parameters, the unauthorized disposition of fetal remains can be prosecuted just the same as unauthorized disposition of a dead body. So those two terms are used there. So if you look and you go back to your bill that's in front of you, the term that is used is the dead body of a person. Right. And that was intentional. So I think the bill might have, like when it was first introduced, I think it might have said like abuse of a corpse or that term. And so the House changed that to use this term that is used in existing law when we're talking about the dead body of a person. But I think because when you look at the sections of law in Chapter 107 and they use these two terms sometimes in the same sentence, it's clear that fetal remains and the dead body of a person are two different things as contemplated under the law. Okay. So that I think was the kind of big concern, and it's understandable because it's not easy to tell that. You got to kind of go and start digging around in Chapter 107 and read through the statutes to really understand how they all work together. And like I said, I'm not the expert on Chapter 107 and all of that. And I think that people have maybe concerns about how that chapter is structured and might need some updating. But that's really kind of a side issue to this. I think your focus is on getting some comfort that the terms that are used here, we're just talking about a dead body of a person and not fetal remains. And so going back and looking at the language, you just have the primary offense in subsection A, and then you have the heightened offenses with a 15-year felony if violating subsection A for the purpose of concealing a crime or commit sexual conduct upon the dead body of a person.
Thanks. So I just want to make sure that I'm 100% clear on this, that under current law, somebody who improperly disposes of fetal remains is subject to the felony described in 5211.
Yes.
Okay. And this proposes to change that, among other things, proposes to change it to a civil offense.
Correct.
Committee, any questions?
Yeah, y'all are easy this morning.
Right.
Yeah.
I feel you.
How does the committee feel about this amendment in general?
I think we've met or attempted to have met everyone's concerns involved in testimony and whatever else here in this particular bill. I'm opposed to the bill, obviously. I want to make sure that all parties are happy when we walk away. And I'm not very happy or not. Okay. I want to make sure all parties are satisfied with the final results of the bill here. I can vote in favor at this point. If we don't do anything drastic at this point.
And it sounds like there's more work to do in protecting living people who can get pregnant. But this certainly is less concerning to me than what the original was.
Yeah, I think, the biggest piece for me is the fact that, the felony already exists. And this was a shock to me when I fully realized that the offense exists now. to potentially prosecute somebody who miscarries and charge them with a felony. And I think taking the step to, I mean, ideally, I would like to make it just not an offense at all, but having it be a civil offense.
Why
Definitely
are
makes
just
sense.
making it non-offensive?
I think that there can be circumstances where there can be mistreatment in a, perhaps a health facility, or if a doctor is not doing their job properly, if there's a medical malpractice case. That's my first thought.
But if we made it not an offense, that wouldn't prevent a doctor from being charged with medical malpractice, would it?
Yeah, that's different than civil offense for the unauthorized burial or removal. Well, thank you.
Sure.
Jess, Artfus, did you want to testify or? Okay. All right, great. I think we're done for now.
Would you like to go out live?
No, we'll just, hold on for one quick second. I think we're gonna shift gears to the budget letter here. So I made changes that we discussed yesterday. I added a few caveats to different areas. Included what the original request was and whether or not we made any changes for the original request. It's on the page. I think what might be helpful appropriations committee is if we pick several of these requests in general, lump them together, an area of top priorities. Yeah, so that's my initial thought on this. Or do folks think that we should just leave this as is and have appropriations figure it out? And for this, I defer to Senator Norris, but if you know what works better or not, the appropriations.
Well, I think it's up to this committee to list their priorities. They don't have to be in order, obviously, to present something.
Yeah.
For appropriations, and then I think everyone here realizes that not everything's going to be fulfilled here as much as we would like to fulfill all of these requests. I can assure you that this is, having been there for the first year, I can assure you this is a very tough year from what I've been hearing from my counterpart sitting on appropriations. I did have a question in reference to the Department of Corrections. Great Child Service Bank. We talked about this, right? Because I believe it was just starting recently. We wanted to hold off on that until we get some data and so forth. So we're pushing, not putting in the request for that. I mean, you know, it looks fine. There's a lot of important issues here that we have to address. Try to give those resources to everyone that we can possibly do. And we'll one person on the committee, just think that have input to this, but it's nice to receive something from this committee and say this is what we want to endorse, so to speak.
I feel like we already reviewed the things and sort of these are the priorities. I don't know. I don't, as I look at what we're coming forward with, I'm not sure how I would rate, like, it's all important.
Yeah, I mean, I'm not thinking of doing like a number one, number two, number three type of priority list. I'm thinking more of a, top three, top four, saying these are essential. And yes, the rest are important, but these three or four categories are linchpins for making sure the judiciary system at least at its core, is popular. Because I mean, it's, in my opinion, it's impossible to say that, you know, the defenders need more money, the essays don't, or vice versa. But I think that just in terms of what I view as our responsibility, making sure that the judiciary system, just at its most basic, is still able to function. So if I had to pick, I had to pick three that I would describe as priorities. In my opinion, I would say states attorneys, Attorney General, and Human Rights Commission. Those would be my top three. If I had to add a fourth one, I would say the Vermont Bar Association, their request for access to justice.
Is the Vermont Bar Association, what is that? Should you have a league, or what is that? That's what you guys put money into.
Oh, the IOTA.
IOTA,
Yeah. So, I mean, their request was essentially to go copy it. Yeah, there's the IOTA account, but I think what they're asking for is something different. Well, let's see, Bob, pay around that.
So I certainly don't disagree that those things are all really important. And I'm pretty uncomfortable without prioritizing, given what we've heard about the impact on public safety in our communities and the overall savings to the system. I would be pretty uncomfortable not putting in a priority list the network ask and the Attorney General's ask. I mean, those, you know, we talk a lot about the expenditures we need in the system, but I think it's also really important that we're looking at what we spend that actually saves the system money. And certainly when I, you know, when Sarah Robinson was here discussing the loss of services to a community and the increase in domestic violence and murders, that feels pretty important to me to prevent that.
Yeah.
I also always think of the sort of return on investment, and that's where the Attorney General's aspect comes down to me. You know, it costs significantly less to keep people out of the system. And so for me, that's cost savings.
So your top would be the AG and the network.
Well, this is why I have a really hard time listing them, because I agree that the things you listed are priorities, and I think it's leaving out, you know, really important cost savings and public safety expenditures. The Human Rights Commission is certainly on my top as well. Yeah, just given where we're at.
We also don't necessarily have to list the top three or four. It was just an idea that I had in order to have these recommendations. If it's,
Well, I imagine Zane will have you in to explain this.
I don't see any reason in attempting to, other than our personal opinions, attempting to prioritize all of these very important functions within the state of Vermont. Because we're all going to have differing opinions on what should be first, second, third. That's great, but I don't know how you prioritize as a committee 1, 2, and 3 to all of these very important functions within the state.
Yeah.
Oh, I don't want to pick and choose sides.
I think I agree with Senator Morris.
Oh, well.
well, Sarah Mattis, what do you think?
Yeah, I agree. And it's hard to rate our requests, you know, trying to get the system all together. They all have valid points. And, you know, judging by the times that we're in now, you know, the Human Rights Commission, Network Against Domestic and Sexual Violence, you know, everybody makes a good case. So I can't rank them, so to speak.
Yeah.
We're going to have to rely on our esteemed senator from Franklin to advocate for our causes here, and his staff every day.
Well, and I think too, they're interlinked, you know, if we
Yeah.
move fund, you know, we prioritize this piece, it's actually impacted by not prioritizing another piece. Like the pieces all work together.
As we went through last year, we approved 3 judges positions. There's gonna be a trickle down or a trickle up effect as far as the state's attorneys, the defender generals. It's tough anytime you have positions, everyone's gonna need positions when you start adding positions.
Yeah, I mean, I generally agree. I think that, you know, Andy or Senator Kirchlick was talking about, you know, in our caucus meeting, trying to create a list of priorities. So wanted to explore the conversation of whether or not we could come to a place where we would be doing that. But I think, I mean, all these points are, I agree with. So it's, you know, putting money in one area, this system will have an impact on another area.
Yeah.
If it's not prioritized. It's trying to fix an engine where you fix one thing, but 2 other things over there, at least breaking. I mean, I'm fine with leaving it as is. You know, I incorporated a few caveats here and there. DOC, which is on the third page. Some Defender General, one with Defender General. It's an explanation. Does anyone think that we need to put any additional notes anywhere?
No, and I like it, you know, DOC provision here. It's just easier. I mean, for the pretrial service expansion, putting a hold on that. Full support of $200,000 for DOC. If in fact it's even needed for the purpose, something like that, but that's the appropriate discussion.
Yeah.
So yeah, that one's pretty clean. And you get those state's attorneys and sheriffs.
Yeah.
So they're all.
Darn states attorneys.
I don't know, it might be the sheriffs.
Them too, yeah.
So we have you guys in the room and we did make some pretty substantive changes. Do you wanna chime in on what we
I don't know, because Tim Leader's from my Department of State Attorney Sheriffs. I didn't see it on the website. I'm happy to take a look.
got it? Yeah, it's just a draft.
Is that okay?
Yeah.
Okay.
Yeah.
And maybe our Director of Operations could also take a look as well.
So you're aware, when they look at it, property ranges up. And that's what he's saying, 600 to 11 vehicles like that before they pull it, so that's 6. Both the states and
How should it be phrased?
see what you can do.
Just a couple minor technical things. This is very much appreciated. In the first bullet point that you listed here, there is actually a need for 650, a reset of 650 for both the state's attorneys and the sheriffs. So
Senator Norris was just mentioning that. So
yes,
how should the language be phrased?
it would be to eliminate vacancy savings for $650,000 for state's attorneys and sheriffs and add to the base.
It basically, basically, it would say something to the effect of restore $650,000 to the base budget for both the state's attorneys and the sheriffs in order to eliminate the vacancy savings need.
And my understanding is those vacancy savings are not really real. Like those vacancies are not vacant.
Correct.
Okay.
Yep.
I mean, at any given time, senators, you know, because of churn, you could have, you know, I could sit here today and say we have no vacancies and tomorrow we have two, but correct. I mean, that it would be at this point, we're well, you know, we're doing well and keeping our staff.
Congratulations.
Yeah. I say not.
Essentially, it's a target that we had to meet, and we don't want to meet it because we have staff in those positions who are doing their jobs right now. And it's important to the work you're all working on. The second piece is I would separate.
That's before that, just make sure I wrote it down
Yes.
correctly. It should be rephrased to restore 650,000 in vacancy savings to the base budget for both the state attorneys and sheriffs in order to eliminate vacancy savings.
Yeah, 650 to the base in order to eliminate need for vacancy savings. Yeah,
1.2.
Okay.
To both,
It's just 1.3.
which I certainly support. I mean, given that those vacancies are not actually vacant and our state's attorneys are carrying caseloads of 350, I don't think we should be asking them to take more.
And restore 650 to the base budget for both the state's attorneys and sheriffs in order to eliminate vacancy savings.
correct.
Okay.
Absolutely. Thank you.
Which the House did that, correct?
Yeah.
The House did do that, with much effort.
So it's a total of 1.3.
That's correct. And then the second piece, in the parens, in the first bullet point, that is unrelated from vacancy savings. The conversion of the 9 limited service positions to permanent positions, I would put that as a separate bullet point because it's unrelated to vacancy savings.
Strike that.
And has no cost.
Zero cost because we have all of those dollars in our budget and the positions.
And the positions are full.
But we have, Annie can
Yeah, 7 of the 9 are full. One is currently in negotiations with Chittenden County to come to work. She's trying to get here, whatever. And one, I think, of the vacancies we will try to move to Essex County to help alleviate the backlog that's growing there.
Other than that, this is deeply appreciated. I just wanted to state again that our office has 1 fiscal staff person. And we serve 29 offices, 175 employees. So fiscal support person, for our central office for the statewide work that we do. Annie and our fiscal support team, Barbara and Aditi, are constantly responding to reports and requirements, not just in the legislature, but from the administration, from the federal government, and from entities that we work with. And so it's an incredibly needed job. This department, we've been on a shoestring for a while on fiscal support. And the concept of key person risk is something I think about a lot. When you lose someone with experience in government, you need to have someone else who's ready to go on the fiscal stuff for our department. So thank you so much for this.
So I did have a question. If I want to just hit it for a second here. So I hate to mention names, but Barbara's going to be there.
Barbara Staples.
Okay. When you decide to retire after many years of service to the state, thank you very much. Your position is still going to be there.
Yes. Yeah, I was hired as the labor relations and labor policy, person. We get so back in 2016, there was a Vermont Supreme Court case called In Re Election that basically said the Vermont Department of Human Resources can no longer provide any labor relations assistance to the Department of State's attorneys and sheriffs because they said, in essence, we cannot guide county government. They viewed all of our employees, which was really crazy, as county employees because they work for a county elected person. But every one of our employees has a state employee position number. They're guided. They're in the state retirement, state health insurance. I mean, it's basically, if it quacked like a duck, they called it a pig. And it was a very odd decision. But as a result of that, the Department of Human Resources said, well, we can no longer provide you with any assistance with labor relations. We will let you put your timesheets through the system, and we'll let you stay in the payroll system, and we'll let you stay in the health insurance. You can't negotiate it, but you can be part of it. We'll let you come through some of the bigger systems. But in terms of anything you need, if there's an employee FMLA, if there's a discipline issue, if there's a performance issue, if there is hiring, we will post. We will not do your postings. You have to post, and we'll let them come up on our website, but we have nothing to do with you. So Senator Kitchell, Senator Sears, and I think primarily in the Appropriations Committee that year said to then Director Campbell, you need to hire somebody, right? And he said, yeah, we have no assistants anymore. And I was between positions because I had been out of the labor commission when Governor Scott came in. I had been working for Governor Shumlin. And so I was up in Chicago, and John called me and said, can you come talk to us about coming to work? So I came to work because I've been at DSEA 30 years, UConn 3 years, labor commissioner 6 years. So they asked me if I would come do this. And I said, sure, thinking that, until they, maybe decided they wanted to do something different. But my job was hired as labor relations, but because I had done budgets in state government, particularly at labor, we have a $343 million budget with the UI fund. Barb needed help. I just basically jumped in to help her, and I've been helping her ever since. So would we look for someone with a skill set that maybe could do the labor relations? Because I negotiate the contracts with our two bargaining units, all that, handle all that stuff. Would we look for somebody who could continue to help in operations? Yes. But, would we be equally served having a fiscal person / IT? We told Senator Norris we could use a little bit of that. We might find that as a skill set a little bit differently. It's not that we would abandon, we work as a team over there and we would not abandon it, but it's hard to know what skill set we're going to find when you post for a labor relations director. Do they actually have that?
But she's trying to say
budgeting
is, what
background?
I will say, she's irreplaceable.
No,
And
no.
I'm saying she's irreplaceable for the department. And so when you do lose someone to retirement and hanging out with grandkids, which everyone has a right to do, we do, government sometimes has to contend with that. And we're going to sorely miss her whenever she decides to leave, which will be too soon for me. But we're also going to need to make sure that you all have the support that you need. The financial side, and that our field of 175 employees, has the service they need from our Montpelier office.
So just so the committee's aware of this anyways. And we were able to come to a compromise as to, well, combining the positions because one is better than none. So that this is a new position. We talked about other comparative things here. I just want to let you know this was combined position, such as we're discussing, but the new position.
This looks, we really appreciate this. And I appreciate the bulleting rather than numbering, because I think when you create the tiers and then there's numbers, people start to think that there's reference, which is something we had to contend with in the House. And so similar memo from House Judiciary, people got a little confused when there was numbering. And it wasn't intended to always be reference. Here with the bullets, what you're talking about, deeply appreciated. And our department watches your testimony committee in here. And they've seen that you focused on the whole intercept, 0 through however many numbers are on that intercepted, because we touch the whole thing. And before there's a charge, we're also involved. And so supporting the whole spectrum is really needed. Thank you so much for the time. Any other questions? And thanks for letting me take a peek at this.
Yeah. I think
Right.
I don't need them up in the notes.
so. I will make some of these changes, mainly with the language, and also put a note in the opening paragraph that these sections are not listed in an order of priority that way. So that if they look at this, they don't think state attorneys are number 1 and the network is number 8 or 9. And with those changes, is everyone fine with having their electronic signature on this letter?
Yeah, I just want to, are you still going to make the recommendation that we convert the 9 limited service positions to 9 permanent positions, perhaps with the caveat that it is cost neutral? Because I do want to make sure that that happens.
I was just going to strike that language because I don't think. I mean, if there's a strike through of that language, is it still going to happen with the 650 that we're talking about?
My recommendation is it's a separate bullet point because it's a separate topic.
Yeah.
The conversion still needs to happen. It's separate from vacancy savings, entirely
Okay,
separate.
so I'll just,
And I think you can just make the note that it is cost neutral.
Yeah.
Yes.
Yeah, it could be as simple as conversion of 9 limited service positions to 9 permanent positions, comma, cost neutral or $0 needed, something like that.
Even using maybe the term current, the 9 current limited service, because they exist and they're in our budget.
Yep.
any questions further on this? You good with it? Okay, great. All right, so we'll be back at 10 to talk about salt. And we can